morning to some of you and good afternoon to everyone else. Welcome to Departing Ethically, 5 things that IP lawyers should evaluate when transitioning firms. The purpose of this CLE is to help guide practitioners as well as law firms in understanding their ethical obligations when engaging in lateral transitions. Lateral transitions could be between law firms or also between going from a government agency to a law firm, or even going to and from in-house to a law firm. Presenting is myself, Emil Ali, and I'm a registered patent attorney that focuses my practice on the intersection of IP and legal ethics. You can view my bio later on, and please feel free to check out our blog, which is ipethicslaw.com. So in today's focus, we're going to talk about lawyers and their law firms and who owns their clients. And a hint, both lawyers and law firms don't own clients because clients are not chattel. We'll also talk about how communication to clients about a departure is key. We'll also talk about conflicts, which are very IP specific in nature, as well as the special duty of disclosure for those who practice before the USPTO. Of course, we'll talk about how to avoid problems by not playing games, what to do with financial constraints, right? Think about the contracts that some of us may have signed. And then, of course, we'll conclude with some wrap-up conversations and with some questions. However, I do encourage you, since this is a live program, to ask any questions that you have, and hopefully I'll be able to address them on the slide that we are discussing. So let's go into the ownership of clients. So as I hinted to you in the beginning, no one owns clients. Clients are not chattel. It's not really the attorney just because they own the relationship within the firm. They may get some sort of origination credit, does not mean that they decide who goes with them and who stays. It is very influential. For example, if an attorney is going to work at the patent office, if they're leaving private practice to go be a political appointee or a patent examiner or a trademark examiner, it's unlikely, or in fact illegal, for them to continue that client relationship, with the attorney-client relationship. That's different. If a lawyer is moving from one firm to another, that lawyer, and we'll discuss this a little bit later, has to give that client options. That option could be staying with the existing firm. That could be